All right, some more latest updates coming in from the Rajasthan High Court as we talk about them, that this is the order that has come in, that Rajasthan High Court maintains that the Supreme Court order maintains status quo as per the Supreme Court order. All right, we need more details to clarify on that bit, but the order details are trickling out as we speak. So there is no judgment by High Court today. The High Court has left it to the Supreme Court to decide on the matter. Utkarsh is with us on the broadcast to put this more clearly. Utkarsh, just clarify the situation. What does it mean going forward?
You see, this was the alternative available with the High Court after what the Supreme Court had to say a day ago. There were certain points of law, constitutional interpretations that...
All right, sorry Utkarsh, I'll come back to you. Some reaction coming.
Prayer 4 रिजेक्ट नहीं करी गई है. Prayer 4 और prayer 3 और prayer 4 उस पे कहा गया है कि हाई कोर्ट के क्षेत्राधिकार में नहीं आता, इसलिए इसको हम नहीं सुनेंगे. प्रेयर ए, प्रेयर बी और प्रेयर ई इसी पे सुनवाई होगी. और जो स्पीकर महोदय द्वारा 14 जुलाई को अपने ऑर्डर दिया गया, समन किया गया था, उसको कोर्ट ने यथास्थिति बरकरार रखने के आदेश दिए हैं. प्लीडिंग कंप्लीट हो जाती है, उसके बाद पार्टीज फ्री हैं एप्लीकेशन मूव करने के लिए इस मैटर की सुनवाई को. प्रेयर 4 में नहीं है सर, वो प्रेयर ई के अंदर है. प्रेयर 3 और 4 कहती है कि इनको एमएलए बने रहने देना चाहिए. तो कोर्ट ने कहा ये हमारे क्षेत्राधिकार में नहीं है, ये स्पीकर तय करे. हमारे क्षेत्राधिकार में जो है वो प्रश्न पूछा गया है कि स्पीकर द्वारा क्या ये नोटिस दिए जा सकते हैं या नहीं, और मुख्य रूप से क्या शेड्यूल 10 का 2(1)A अनकॉन्स्टिट्यूशनल है या नहीं. मुख्य रूप से इन पे आगे फैसला होगा. उस पे जब यथास्थिति बरकरार करने के निर्देश दिए तो कार्रवाई नहीं होगी. अब उच्चतम न्यायालय के समक्ष मसला रहेगा कि परसों कोर्ट इस पर्टिकुलर ऑर्डर को कैसे देखती है.
क्या विधानसभा अध्यक्ष एक्शन ले सकते हैं?
देखिए, स्टेटस को का जब ऑर्डर है तो संभवतः अभी तक कोर्ट के समक्ष ये मसला था कि हम खुद समय के लिए कह रहे थे. अब एक स्टेटस को ऑर्डर है, क्योंकि मामला उच्चतम न्यायालय में लंबित है, तो उच्चतम न्यायालय जो फैसला लेता है वो मान्य होगा.
तो सर, इसमें कोई
तारीख नहीं दी है. कोर्ट ने कहा प्लीडिंग्स कंप्लीट हो जाएं, जब एक अर्जी लगा दीजिएगा अर्ली लिस्टिंग की, और तब हम तारीख देकर सुनवाई करेंगे.
अब सीपी जोशी का मतलब पूरा मामला अब सुप्रीम कोर्ट के अंदर चला
यस, सुप्रीम कोर्ट के अधीन रहेगा मोटे रूप से.
शुक्रिया, बहुत प्रतीक्षा. देख सकते हैं यहाँ पर
CP Joshi's lawyer, he was giving us the details about what the order is. I want to go back to Utkarsh Anand for more details on the story. So Utkarsh, would it be correct to say, you also I hope heard the lawyer, that there is more time that the Sachin Pilot camp will have? There cannot be any adverse action taken by the Speaker's office.
It's absolutely right. In fact, there have been multiple issues which the Sachin Pilot camp's petitions had raised. Based on that, about the declaration of the aspect that they are still the members of the Congress, they are still the MLAs of the Congress party. On that, the High Court, Rajasthan High Court has said that this is not a declaration that a constitutional court can do. It's a completely political question. It is for the political party to decide who is an MLA, or the assembly to decide, the speaker to decide about on all this. But we are not going to make a declaration to the effect that someone is a member of a particular party or someone remains an MLA or not. That is not within the jurisdiction of a High Court to say. About the other questions wherein the merits, the manner in which the notices were issued to the speaker, by the speaker to the MLAs, 19 MLAs. On that, the court has said that yes, we will examine it. About the challenge to clause 2(1)A of the anti-defection law. On that aspect also, the High Court has said that we will examine that particular question also. And for that purpose only, the Union of India has been included as a party. Union of India has been included in the notice. That on the anti-defection law, Union of India can also present its views to defend or to say otherwise about clause 2(1)A. That is some substance under of a political party bill speaking out against your own party amount to give it in but not is the question.
All right. Utkarsh, there's a problem with your line. I think we need to reconnect to you on that one. In the meanwhile, I'm going to Pallavi, who's also with us on the broadcast. So Pallavi, as Utkarsh was pointing out, there's a status quo that has been ordered by the High Court. Now, the entire matter will be dealt by the Supreme Court. And in this, the pilot camp gets far more time. The situation will be in a sort of a limbo, as it is. So clearly, this is a setback for the Gehlot camp.
But see, frankly speaking, the pilot camp was expecting some kind of a decision from the High Court, but they would still have to wait till Monday from the Supreme Court for a complete clarity. So in that sense, the wait is just for another 2 days. So one is hoping that on Monday at least, the Supreme Court comes out with a verdict, because the Supreme Court has made it very clear that this is an interesting topic. This merits a lot of discussion. So one is hoping that that decision will finally come in on Monday. Meanwhile, yes, it's a long wait for pilot and the dissident MLAs. It's a longer wait really for Gehlot also, because they also want a certain amount of clarity. But those backroom preparations are going on, and we have spoken about the fact that they do plan to call an assembly session to checkmate pilot and the dissident MLA. So let's see whether they're going to use this time to do so. A 3-day notice is mandatory. That's what the Speaker's office is telling us. So that time will have to be utilized to actually call an assembly session.
Pallavi and Utkarsh getting us all the very important